Hello everyone, this is Tom Fox and welcome to this episode of Everything Compliance, where together with four of the top compliance practitioners and commentators that I know of, we take a look at everything compliance. We of course are joined by Jonathan Armstrong from Quarterly Compliance today, who happens to be in the former land of the free United States. He's in New York. We have Matt Kelly, founder of Radical Compliance from Boston. We have Mr. Translations himself, Jay Rosen. And we have Mike VOLKOV,
hey, Tom,
the founder of the VOLKOV law firm. And as you just heard, Mike just joined us. So with that, I thought today we would take a one-episode deep dive into the Rolls-Royce case. It just came out a couple of weeks ago, an incredible case to start 2017 with. All of us have been written about Rolls-Royce, and so we're going to take it from our own unique angles. We're going to start with Jonathan, as our UK commentator, will set the table and really talk about it from the UK perspective, the DPA, and what it might mean for the Serious Fraud Office. Jay Rosen is going to follow by talking about the resolution documents, and then what companies who've done business with Rolls-Royce or are even in the same industry might do now to protect themselves. Mike VOLKOV is going to talk to us about what do all these settlement documents mean? What does it mean to have DPAs in separate countries? And then what happens, or how does a company that had a systemic bribery scheme for as long as Rolls-Royce did actually make enough of a comeback that they could get a DPA in both the United Kingdom and in the United States? Then Matt Kelly's going to bring us home today, and Matt's going to really consider the global implications of this settlement. So, gentlemen, with that incredibly long-winded introduction, welcome. And Jonathan, why don't you set the table for us from the UK perspective?
Yes, happy to, Tom. And it's important, I think, to say that whilst this involves a UK corporation, of course, I think it's very much a global case. I'll talk about that in a minute. And it's not immune from the events that are happening in the US. The judge, in his judgment, made it clear that he had rushed through the hearings which are needed in our deferred prosecution agreement process in the UK, that they had been rushed through at the request of the parties because of the uncertainty as to what an incoming Trump administration might do to settlements like this. And it really was quite an accelerated timetable as a result. Now, there's a very detailed statement of facts that outlines the whole case. But to summarize that in brief, the case starts in early 2012 when the SFO discovers some internet postings. They relate just at that time to China and Indonesia, and they show them to Rolls-Royce. Rolls-Royce then is involved in a very large internal investigation. It has cost them a considerable amount of money, north of 100 million sterling, and they widened the investigation beyond China and Indonesia to look at conduct in a whole host of other countries, including Thailand, India, Russia, Nigeria, Kazakhstan, Brazil, Azerbaijan, Angola, Iraq, and Malaysia, I guess most of which companies inhabit the bottom of the Transparency International index that was also out yesterday. The SFO also got involved parallel to the internal investigation, and they got cooperation, particularly from Austria, Germany, the Netherlands, Singapore, and Turkey. And then we have this tripartite deal that Rolls-Royce get effectively with the UK, the US, and Brazil. Now, I guess one of the first things to say is obviously the amount of the agreed payments is really substantial, around 497 million sterling, plus costs to the UK authorities, $167 million to the US, about $25 million to Brazil. Agents are a key feature. I know Jay's going to talk about it. Many agents investigated, 88 suspended as a result of the investigation. It's important to remember that the DPA has been done by Rolls-Royce, but that doesn't protect individuals involved. Around about 11 individuals at Rolls-Royce have left the organisation, and in addition, many well-connected agents and intermediaries are under suspicion, as well as those that received the bribe. And remember that under UK bribery law, it is not better to give than to receive. Both are equally liable to prosecution. And in addition, we've seen, and I think others are going to talk about this, the launch of consequential inquiries, particularly in Asia, that are pinning the finger of blame at some of the individuals whose details are pseudonymized in the court documents. Some of the other key features I think that are interesting to me, I'm a block away from the W Hotel in Times Square at the moment. I hope I'm not in a lavish hotel, because apparently the W Hotel in Times Square is one. And we had all this debate prior to the Bribery Act coming in about the appetite to prosecute things like gifts and hospitality. This is one of the features of this case, involving an MBA program put on by a US university, which involved some of the teaching, I'm adding inverted commas, being done in the Peter Luger Steakhouse in New York, and some of it at the Woodbury Common Outlet Mall. That program cost Rolls-Royce about $3 million US, including a Chinese travel agent receiving $100,000 US for evening entertainment during what seemed to be just a 2-week MBA program. Case also tells us, I think, that gifts are in scope. So the corrupt conduct, for example, includes 2 Rolls-Royce branded watches. It's important to mark, I think, at this point, the clear distinction between Rolls-Royce, the car company, and Rolls-Royce, this Rolls-Royce, the aero engine, industrial power, etc. group. 2 separate entities, and there's been some misinformed speculation about Rolls-Royce, the car group, being involved. That isn't the case, although coincidentally some of the gifts were branded as car company products, and indeed a car was one of the gifts. The investigation was...
John,
yeah, sorry, Tom?
Stop you there. Even in today's Guardian, there was an article about Rolls-Royce that had a picture of the car in it. So if the UK newspapers are confused, what does that say about the rest of the world in terms of the name?
I think it is confusing, and I guess if you're the owner of the Rolls-Royce car brand, and you've paid good value for it, then presumably you're going to be a little bit annoyed at the moment, aren't you? I mean, it seems to me that that it is a source of some confusion, and if I were BMW who own the brand, then I might want to be making it clear that these acts aren't to be laid at my door.
Absolutely. So sorry, I'm struck by that anomaly.
Yeah, and then one other. I mean, I think you're right that there are 1,001 different things we could talk about. But one, just for the basic introduction, that really interests me, I think, is this is certainly a huge investigation in terms of the amount of documents that are sweated as well. So 229 internal investigation interviews, 250 third-party relationships reviewed, the email accounts of 100 current or former employees were handed over to the SFO without asserting privilege, with an agreement that privilege would be determined by an independent lawyer. And this led to an investigation, digital examination of more than 30 million documents. Now, I think we talked just before the holidays about the conversation I'd had with David Green about his new supercomputer and acquiring 2 petabytes of data to sweat in that supercomputer. And it'd be interesting to know how many of his 2 petabytes came from Rolls-Royce, and if indeed that's in addition to the big pot of data he'd already collected. And there's quite an interesting undertaking, effectively, that's reflected in the judgment, that Rolls-Royce say that they will keep all of the documents collected within the UK jurisdiction, presumably to avoid any data privacy, data export, spoliation type arguments, and they'll make that available for subsequent prosecutions as directed by the SFO. So, as I say, we could probably touch on about another 10 things that I think are significant in the case, but I wonder if that's a good start, Tom.
It is an excellent start, and I thought maybe at this point we might throw it open to the rest of the roundtable to see if they had any questions of Jonathan from the UK perspective.
Jonathan, I do have one question. How much is this a big, I guess, publicity victory for the SFO? Because they're always on the back foot about, do they have funding? Will they be taken seriously? I mean, this seems like a mighty nice feather for the director, David Green, to have in his cap, but how true is that?
I think you're absolutely right, Mike. As I say, I was at an event he was at just before Christmas. He did seem to me to look happier than when I've seen him on other occasions. Maybe I'm reading too much into that. Maybe it was just the holidays. But this is a great win, I think, for him, given particularly Theresa May's, let's just say, lack of enthusiasm in the SFO. Interestingly, I understand that last night David Green said that he did not intend to renew his term, so he'd be going by the end of April 2018. He said that we could expect more DPAs imminently, and obviously he's trying to wrap up most of his big cases before the end of 2018. So that will have implications for other corporations like Alstom, Airbus, Tesco, GSK, who are under investigation. And I think that this is definitely a fillip for the SFO, and it will be a confidence boost. Absolutely right, Mike.
Jonathan, I wanted to ask you about a couple of the judges' comments. First of all, in not even really oblique language, he was highly critical of the very senior executive level of Rolls-Royce. Now, he didn't name any names, but he did say quite clearly senior level executives. The second thing was he really gave, I thought, one of the most detailed and thoughtful analyses of why it is not in the interests of either the British government or indeed the British people to put a company such as Rolls-Royce out of business. And that it's very important to the British military, very important to the British government, very important, obviously, to the workers, not just at Rolls-Royce, but all through up and down the supply chain, and even the towns where Rolls-Royce has facilities. And that sometimes I don't think is really articulated as well in the United States regarding one of the useful aspects of a deferred prosecution agreement. What are your thoughts on those 2 points?
Yeah, I think that's a very interesting aspect as well, Tom. I declare an interest in that I live in Derbyshire, where the majority of Rolls-Royce's employees, I guess, in the UK reside. And it is definitely important locally. You know, where I live, Rolls-Royce is an iconic business. It's the one that any kid who's interested in engineering dreams to work at Rolls-Royce, and they do great outreach work into the community. I think it's a very thoughtful judgment, particularly given the time constraints that the judge was under. The judge, obviously, Sir Brian Leveson, has the advantage that he was the judge in the 2 other DPA cases, Standard Bank XYZ, so he knew the law around it, and obviously he had assistance from the lead prosecution counsel for the SFO, Sir Edward Garnier QC, who, when he was in government, had brought the DPA system in. So it is sort of, people who've been round the block insofar as anyone has on DPAs. But it's a very thoughtful judgment, and to produce, whatever it is, I guess, 144 paragraphs outlining his reasoning, and also to append all of the calculations which show how the amount is arrived at, I think is an extraordinarily thorough piece of work, as I say, given the time constraints that everyone was under in this case.
Well, Jay Rosen, could we perhaps turn to you, and what were some of your initial thoughts in reading these materials?
Thanks, Tom. One of the things I'd like to do is springboard off a post of yours from earlier this week. And you had tweeted in part 4 of your blog on the Rolls-Royce enforcement action that Rolls-Royce confirms anti-corruption enforcement has gone international. And as a CCO, I would be ready. So I'd like to take a look at this global piece, specifically the bribery schemes in the different jurisdictions that were sanctioned by the DOJ, SFO, and I'll probably butcher this, but the Brazilian Ministério Público Federal, the MPF. And before we kind of drill down into the countries involved, we need to lay out the divisions that were accused of conducting this bribery. And to both Jonathan and your point earlier, the misconception is that this has nothing to do with the automobile brand, but there were 4 different divisions of Rolls-Royce that were affected. There was civil aerospace, which in the documents is known as civil, the defense aerospace business, which is defense. Then there's Rolls-Royce Energy Systems Incorporated, which is abbreviated as RRESI. And then there was also a marine division that they looked at, and the SFO decided that there was not enough evidence against the marine division to continue to prosecute them. So all of the DOJ actions resulted from the Rolls-Royce Energy System, and those locales where things happened were Thailand and Brazil. And guess who was involved in the scheme in Brazil? If you said Petrobras, you're definitely right. Kazakhstan, former part of the Soviet Union, Azerbaijan, Angola, and Iraq. So while the SFO actions resulted mostly from the civil division, there was also a single defense infraction and 3 energy schemes thrown in for good measure. So if we look at the the countries where Rolls-Royce had issues under the SFO, civil issues in China, Malaysia, Indonesia, and Thailand. So we're talking the Far East there. The loan defense issue in India, and then the energies issues in Indonesia, Nigeria, and Russia. So the global corruption enforcement action here really points up to the changing nature of the international fight against bribery and corruption. And regulators have now moved past simple cooperation, and this matter is a real good investigation about how they've worked together and actually collaborated on the enforcement part. To take a quote that's been out there, Assistant Director in charge of the FBI's Washington field office, Paul Abate, if I'm saying that correctly, says in the DOJ press release, this successful parallel investigation is a tremendous example of the central importance of working cooperatively alongside our international partners to achieve a fair and meaningful resolution. This outcome reflects the immense reach and capability of the FBI's Washington field office, International Corruption Squad, and the global impact of the anti-corruption program. Further, in addition to the work of the SFO and the MPF, as Jonathan noted earlier, Austria, Germany, Netherlands, Singapore, and Turkey provided significant assistance to the DOJ. I don't want to get into the minutia of the charging documents or the statement of facts, but it's pretty much safe to say that as you go by jurisdiction to jurisdiction, you'll see that there are influences of just outright bribery, dealing with third parties, dealing with people in the government. So, it gets to be a bit monotonous after you read the charging documents. but you can see that over this long time period, the management definitely turned a blind eye to what was happening. Getting back to the aspect of global corruption, for those of us, myself included, who are worried about the United States' commitment to fighting global corruption under a DOJ now that will be led by Attorney General Sessions, I think we can hopefully count on our global anti-corruption partners to pick up the anti-corruption mantle. And even if we see the DOJ and the SEC resources becoming constrained in the future months, that we've kind of started a global fire. Next, I'd like to consider the second part of Tom's tweet. And he asked, if you're the COO of a company, and I'm adding whether you're in the US or the UK or anyone else in the world, and you find out that your company did business with Rolls-Royce, what's your next step? So if I was that CCO of an aerospace company, either civil or defense, I would go back over my bidding procedures and take a look at my salespeople and any intermediaries or third-party agents who are involved in any tender processes involving Rolls-Royce or in the jurisdiction where Rolls-Royce admitted to the above bribery schemes. And I'd ask the following questions. How were these agents compensated? Did their compensation raise any red flags internally? Were improper payments made? Were all commissions properly vetted and signed on and signed off by the appropriate members of your organization? Next, I would investigate the third parties that I'd work with. And do any of these people still work for your company? Have they worked on any other bids? Have they been involved on tender offers with other products in the same geographies? Did you perform adequate due diligence on these business relationships the first time? And even if you did, might it be time to update that diligence? If you notice how FCPA and other enforcement matters seem to evolve, there are certain industries that historically come under scrutiny, namely the energy sector, pharmaceutical and life sciences, and the defense contractors, to name a few. It is no coincidence that as soon as Volkswagen recently settled its defeat device issues with U.S. authorities, that Fiat Chrysler was subpoenaed on a similar charge. So if you extrapolate this thinking forward, and if you are a defense contractor, not necessarily in aerospace, but in a related field, and you have done business in either in the countries that Rolls-Royce has, or if you've worked with Rolls-Royce as a bidding partner, then as Ricky Ricardo used to say to Lucille Ball, Lucy, I think you got some splaining to do.
Somebody obviously agrees with you, Jay.
Yeah, that was Lotka giving his support to my Ricky Ricardo impersonation.
Tom, I think Jay makes a really good point. And the other thing I might just add to that is these offences, some of the offences predate the Bribery Act coming into force in 2011, but some post-date it. And it could be the case that some of the other companies involved have almost got bigger problems. Why? Because even though there is criticism of some of the training at Rolls-Royce, it being sporadic and not thought through at times, at least there was training. And my experience is that many of the corporations that employ people in procurement do no training for procurement guys at all. They're very FCPA focused on the giving elements rather than Bribery Act focused on receiving. So I would be astonished if we don't see some consequential action against some of the organizations that have bought this kit.
Jonathan, Jay detailed a pretty good list of things companies should do, but in the United Kingdom, there's an additional obligation on the board beyond what Jay has articulated that a CCO should consider, and that is that what steps has a board taken to prevent bribery. So how would you maybe suggest a board start to look at these things separate and apart from Jay's very excellent list for a CCO?
It must be a standing item on the agenda of every board. Even if it's a standing item on the board and they say nothing to report, I think it has to be something that every board meeting discusses. All of the people on the board need training to spot the risks. You know, we've talked about the Braid case before the holidays, where there's this additional consequence for executives who don't do that. And it's important to remember that, you know, this Section 7 offence, which is a feature of this case, is a failure to prevent. It's not, you don't have to have knowledge, I think, if your processes aren't correct, if an act of bribery occurs. And I think your earlier point was well taken insofar as distinguishing between employees of the business and senior employees. These two terms appear throughout the statement of facts and the judgment, and the judge has been careful to identify where he thinks that senior employees are involved. And of course, there are rumours of some of those individuals, although they're not directly identified in the judgment, as to who they might be and the heat that they are likely to feel. So I think this is a case where the SFO would like to press on for convictions of individuals as well.
Hey, this is Mike, Jonathan. I wanted to ask you, because that raises the interesting question about individual liability of culpable officials here. I mean, do you see that, unfortunately, the pattern in the U.S. has been corporate settlement and really not many follow-on individual prosecutions. Do you think there's a chance that the SFO will bring a case against any of the individuals in this in this matter, given with the company's cooperation, I'm sure?
Yeah, I think it's always a challenge, isn't it? The track record of, I think, all bribery prosecutors is not bad against corporations, mostly because they settle, but isn't great against individuals. But I think there will be pressure to look at some of the individuals here. And I think in some respects, the thing, to my mind, that makes it more interesting is this pot of 30 million documents and the fact that e-discovery techniques, have got better in the last few years with things like semantic search and so on. So it seems to me that that I think the chances of an individual prosecution are better. I think it's instructive that the statement of facts does show awareness on behalf of some employees, and there is a direct quote, for example, from one of the emails that's discovered. This involves the Russian bribery, where one employee says, I told the Rolls-Royce employee in Russia on Monday, I do not want to see any of this stuff appearing in an email in future. If he does it again, I'll bring him back to London so we can give him a face-to-face scrubbing. And there are also other emails, I think, where the parties to the email are agreeing to switch to telephone, and others where they're agreeing to switch to BlackBerry Messenger instead, presumably because they think that they are both ways of evading detection. So I guess if I'm, the Sherlock Holmes of the SFO, my plus here is that I've got quite a lot of evidence to try and get a personal prosecution. And I've also got things like emails, which are linking things together, but also giving me evidence of knowledge. I guess you don't offer somebody a face-to-face scrubbing unless you think he's doing the wrong thing and you want to hide it.
Well, I think it's going to be interesting if they do bring individual cases. I don't expect the U.S. obviously to do that, but it would certainly be the SFO's, province to resolve the case that way.
So, Mike,
bear in mind, Mike, of course, as well, that after the original whistleblower came forward, or the original internet poster, a number of former employees have also come forward. Some of those have talked to the BBC. So even 30 million documents might not be the end of it. It might be that other former employees have documentation and evidence as well.
The other thing the other point I was going to say is that I know that we owe our livelihoods and our country to the Brits, but the Brits have certainly, with the writing by the judge, or with the sort of reaction of the judge and the factors that are laid out by the by the SFO, I thought it was really great to see sort of the transparency of the thinking. And to me, it's a model for how the U.S. should be doing DPAs if they're going to do them anymore under the new Attorney General. But, and I think by doing that, they really give great guidance to people in terms of understanding what cooperation means, what the range of alternatives is. And it's just a much more transparent system in the end, I think.
I think that's my thing. I read a whole bunch of documents on the plane over here, and I'm literally conflicted. You read some of the facts, and you're ashamed of your country, and you read the way in which the court has dealt with it, and Rolls-Royce to an extent, and the SFO to an extent, in a very transparent way, and it sort of tempers your shame with an element of pride that at least these issues have got out into the open and are being dealt with appropriately.
Oh, you really need to get over that. In Texas, we're proud of all our crimes and our criminals. That's why we're the great state of Texas. So, Mike, before you give your thoughts, Jay asked if you could articulate for the audience what's the difference in the settlement resolutions the DOJ and SEC use. So we've talked about the DPA, but what's the difference in a DPA, an NPA, a declination, and any of the other settlement documents you've seen in the FCPA world?
Well, at least on our side here in the pond, there are several. One alternative that the Justice Department has is a non-prosecution agreement, which is entirely never filed with the court nor subject to the court. Prosecutors have the ability to and are authorized to enter into non-prosecution agreements with individuals, with companies, and lay out certain conditions. So we have that. We then have what is called the Deferred Prosecution Agreement, or the DPA, where we file the government files an information with the court and sets out, let's say, a charge, and the prosecution is deferred during a 3-year period usually. And in that case, if there's anything that goes wrong or they violate the Deferred Prosecution Agreement, the government has the authority to reinstitute the charge. The reason that's filed, and the judge's sort of authority to review the Deferred Prosecution Agreement, is that it requires an exemption from the running of the speedy trial clock. In federal court, barring an exception applying, you're entitled to go to trial within 70 days of the being indicted. You get an extra 10 days if you're arrested and then not indicted yet, or extra 30 days. So there's the good old standard indictment. Interestingly, there's been some suggestion about Senator Sessions, the new Attorney General, to be next week probably, and his sort of disfavor on deferred prosecution agreements. And, he likes the old system, which was you either get charged or you don't. And I always say in that context, be careful what you ask for, because you just might get it, which may mean that more companies may end up getting charged or having to enter guilty pleas or using subsidiaries to enter guilty pleas or whatever. So companies should be careful before they lobby on that type of issue. Then when you go over to the FCC, we have, obviously it's a civil proceeding, and they also have they've created their own tools akin to the Justice Department because it was run by a former AUSA from New York for a while when they did this. And they put in non-prosecution agreements and deferred prosecution agreements for individuals and companies, depending on cooperation. And then they have their traditional authority are cease and desist orders. In other words, to say that you will cease and desist from engaging in bribery in the future, but more importantly is some recognition and some payment of civil penalties or combination of civil penalties and disgorgement. Disgorgement, I think, has become the new hot issue and has a new Supreme Court case coming up this year on the statute of limitations application to disgorgement because the April FCPA pilot program instituted made disgorgement a condition of getting the benefits under the pilot program. So we've seen more interest or focus on the disgorgement concept, going along with civil penalties. But and then we have that sort of combination of tools. Now, still, the SEC is wrestling with the issue of whether they can bring these cases in administrative hearings or whether they have to go to court. They got burned in court because they got a bad draw on a couple of cases that they had. It went to Judge Leon in the D.C. courthouse, which is not a place you want to end up, either as a prosecutor or really any practicing lawyer, speaking from experience, to be honest with you. And so they're trying to do the administrative hearing type of thing.
Well, Richard Bistrong loves him, just in case you didn't know.
Yeah, Richard Bistrong. Well, we all were there with the SHOT Show case, but I actually prosecuted cases, and I had to work with Judge Leon, and I can tell you it was a bizarre world. But anyways, so that's sort of the range. It's interesting to see the SFO sort of dealing with it, but having a judge there. I like the judicial oversight. The real controversy in the U.S. is the ability to conduct judicial oversight when your only procedural hook is whether or not to exempt the deferred prosecution agreement under the speedy trial clock. And, if the courts really want to get involved, they should get a statute that authorizes them to, or requires them to review this, just like in the UK. So we'll see what happens with that. Yeah, go ahead.
This is Jay. I just wanted to thank you for answering that question. And my one quick follow-up is, what is the equivalent of a declination under SEC? Is that cease and desist, or is there also a form of declination?
No, they have a non-prosecution agreement, which is weird. But they have a declination. They're not going to bring charges and all that stuff. They have a very similar. I don't know that they use the same terminology for it.
Great,
frankly, I haven't been in a case where they haven't gotten involved. The FCPA people there have an aggressive reputation. So I'm still looking for my first declination from the SEC. But I wanted to. The comments have been really terrific, and I wanted to only sort of highlight a couple of issues that I thought were really I thought creative and well done by the lawyers, and it paid off. And I hate to use that expression, paid off, but I thought the use of Lord Gold as a compliance consultant his reputation is quite good in the United States because of his prior involvement. I think he was the monitor for the BAE case.
Yeah.
And there was a lot of fighting over the monitor in that case, if everybody recalls, getting a monitor assigned to it. But the use of Lord Gold here as a compliance advisor, and I didn't realize that he oversaw the internal investigation, which you want to talk about lending credibility and pointing out the importance of an independent, no holds barred type of internal investigation. I think that's probably a pretty good person to use to represent that. And I think it helped Rolls-Royce avoid a compliance monitor, because who needs a compliance monitor if you have Lord Gold? And I thought there was a lot of deference on the U.S. part to the SFO, and deference to, I think the SFO had deferred to the U.S. in many other cases, and I think the prosecutors in the U.S. were paying homage and respect to the SFO to say thank you, by sort of letting them lead every aspect of this, and also sort of lead the resolution, I think, by employing Lord Gold in the way that they did. The other interesting aspect to me was, and I think the facts are really important on voluntary disclosure issues. These guys did not get voluntary disclosure credit. And as you said, there were press reports or internet postings that caused the SFO to look at this. And to me, when we sit there and we find something out in a company and we're sort of wrestling with voluntary disclosure, and a press report comes out, and somehow, and I've had this happen in one case, and the DOJ prosecutors are reading the Wall Street Journal or reading whatever, and they see the press report, and boom, you're out. You lose voluntary disclosure credit if you don't beat the press report. That's pretty tough. And, that you could have press reports that are not credible, but, if they are credible, boy, people better be nimble, because losing that here, I think Rolls-Royce lost millions of sterling and dollars with the resolution. And then the last point I wanted to say is, not only as Jonathan, I think you articulated it incredibly well, does this reestablish, and Tom has written about this very well as much, about the international enforcement regime that's coming into focus here. This also shows, I guess, my sort of pet peeve, that if you watch the resources and where the resources are going, you're going to see production from it. So we now have an FCPA unit that doubled in size. We now have AUSAs out in the field that are more comfortable dealing with the issue and learn by bringing a case or being involved in a case. And now you have 3 full squads of FBI agents. And to me, this is the culmination of building resources and how they allocated the resources to, and we've talked about this before, devoting to training other prosecutors, investigators around the world. Now we're seeing the fruit is finally coming, out on the tree. And I think that is really a big message here, that the department told us they were going to do this, and they've done it. And now everybody's like throwing their hands up going, whoa, they're so aggressive. Is this the end of the Obama administration? Everybody wrapping up cases. No, this may be the new norm. And if it is, watch out, because more and more countries are going to get more and more involved. So that I just thought, the SFO told us going back to 2012, they were investigating this case. And the longer it went on, to me, meant the bigger the case was getting, because it took so long to resolve it. So those are my thoughts. But the DPAs, I think, are really well done, well crafted. And I think, this is going to be led from the SFO, sort of calling the shots on how the compliance program and the remediation is working down the road with the report, and Lord Gold sort of overseeing it.
I think, Tom, if I can pitch in, I think Mike raises a point on the almost return of investment that I've not seen anybody raise in the materials I've seen on this already, which thinking aloud here is a really intriguing point, I think, from a UK perspective. Now, we've talked in these podcasts before about the way in which the SFO is getting funding for these cases. It has to apply for what's called blockbuster finance. So it has to effectively do almost a business case for the prosecution. I think if you, the government, invest X in this case, I have a chance of a return of Y. A return doesn't have to be pure monetary terms. It can be, public policy reasons. But from memory, and I may be inaccurate, I think the blockbuster application to run this case was 25 million sterling. And if you look at the numbers, obviously they've got if it was gambling, they've got their original stake back because Rolls-Royce have agreed to underwrite the SFO's costs. And in addition, they've scored almost 500 million sterling for that 25 million investment. So if you're the Treasury Department of the UK government, you're going to be much more likely to offer blockbuster funding next time David Green comes knocking on your door, because the rate, the return on investment is huge. And we can all have these arguments over whether governments and prosecutors should or not take these things into account. But the world we're in at the moment is they do. And this might also, of course, have implications with the Trump administration, like we've been saying, that if they determine that the rate of return on investment in prosecution is this substantial, then it might mean all the things Mike's been saying: better trained prosecutors, more of them, more research capability, more intelligence, etc., etc.
So, Jonathan, you've given us a new TLA, ROI, which is now return on investigation.
Yeah, exactly.
So Matt Kelly, who has joined us off the disabled list, getting ready for the Super Bowl in Houston next week. Matt, maybe you bring us home with some of your thoughts?
Sure. First, I apologize for my voice, everybody. I'm coming off of a head cold. My very first thought, I think we owe Jonathan a debt for talking about the face-to-face scrubbing, because now I have an image in my head of scrubbing of the face as an employee disciplinary action. Great idea for many companies. But I was most struck that for the SFO, this really seemed, I don't want to say it was a U.S.-like style settlement, but the fact is, if Rolls-Royce had been a U.S. company doing this sort of extensive misconduct, we probably would have wound up with an agreement that looks a lot like what we just saw. And there's a certain international standardization of really big telling settlements when we have really big cases of misconduct, which we did. And it doesn't matter that it's the UK or the US. I tend to be a bit more skeptical about the international cooperation and the internal interest in pursuing these cases. I agree with what Mike said, that there is certainly a payoff in the investment here. And I think there's an appetite at lower levels in the U.S. to keep pursuing these cases. I have yet to see a statement from a high-level person in the new Justice Department, mostly because we don't have any high-level people in the Trump administration quite yet, to say what they want to do. I think there's a lot of credit to the idea that we're going to see more declinations, more non-prosecutions for companies if they cooperate and they give us individuals. How is that really going to translate into international cooperation, which is going to be necessary for big cases, for big corruption, which is still out there? When I looked at this case, I counted at least 7 different international enforcement agencies that were collaborating here in one way or another. The word that comes to my mind is there's a sort of a tentative agreement right now. We'll all keep holding hands and marching forward on this, but what happens if Theresa May does take the United Kingdom in a very different light touch low tax regulatory and enforcement world after Britain has left the EU? Who is going to succeed David Green? What if that person is more in that line of thought? What if we have a very fractious sort of Justice Department squabbling with Donald Trump and his tweets about whatever might come to his mind? Because we already see that tension in other parts of the federal government. Now, Jeff Sessions and Donald Trump seem to be buddy-buddy on many issues. I think they have a good rapport. But there's rapport between the White House and the Justice Department and its lower levels, and the AUSAs, who I think their hearts are in the right place. But there's still an awful lot of uncertainty and an awful lot of ways that this could go differently than what we think of and what we've seen up until now. I'm really grateful that we've seen this sort of SFO case, but I think there's still a lot of uncertainty, and a lot of compliance officers are still well within rights to say this is a good blow for effective compliance, but is this going to be the standard? We don't know. That's probably all I can say before my voice fades, but if anybody wants to scrub my face on this because they disagree, go right ahead.
So, Mike, you are our only panelist who actually knows soon-to-be Attorney General Sessions. Any ideas on his thoughts on global or international cooperation?
You know, I don't think he's going to upset any. I don't think he's going to do as much as people worry about in terms of major changes. I actually think the most interesting appointment was his appointment of a deputy attorney general to take Sally Yates' place. Is a guy by the name of Rod Rosenstein, who's the U.S. attorney in Maryland, and before that was in the Bush administration, and was kept on by the Obama administration because of his if you want a word of integrity to apply to a prosecutor, there's not anybody better than Rod Rosenstein. I mean, the Obama administration kept him in Maryland for 8 years. He never asked him to leave. And I know him personally, and I can tell you he's far more ethical and a better lawyer than I am. And he is a terrific person who I think is not going to upset the apple cart here, folks. He is a tough prosecutor. Maryland, in particular, has gone after healthcare fraud and healthcare cases and prosecuted individual doctors criminally. And Rod is a tough as nails prosecutor. So, and he gets along well with people, very well respected on both sides of the aisle. So Sessions did a smart thing, which was to bring in sort of the consummate insider who knows how the Justice Department works. So I can tell you across the board at the department, people have sort of, there's a big sigh of relief as to who's going to be the number two, because the Deputy Attorney General really has a lot of power. And all of the criminal division and the fraud section all report up through the line, and eventually things got to be approved at the Deputy Attorney General level. The cases are signed off. The policy statements, for example, on the pilot program, has to be approved by the Attorney General, Deputy Attorney General. If it goes with that approval up to the Attorney General, it's rarely, if ever, touched. And the Attorney General rarely, if ever, gets involved in those types of issues. So I don't think we're going to see as much change. I think Matt's point is we may see some more declinations. I do think, and I've said that I do think that we will probably see declinations as opposed to a 50% discount given to companies that really meet the requirements of the pilot program. I think that may be tinkered with or changed a little bit, but that's about it. I think it's a really welcome sign. Now, of course, like Matt also said, who knows what Trump will tweet one day about a settlement if it gets on his radar screen, or whatever. Who knows what he'll say. But I don't think it'll filter down to the department to that level. Of course, we also have to say that the department now is supposed to be conducting a voter fraud investigation relating to 3 to 5 I think it was 3 to 5 million illegal votes. So who the hell knows what will happen? But if there's anybody that can push back with reality, it's going to be Rod Rosenstein.
You know, Tom, one other quick point. I agree with what Mike said, and I did see that one of the deputy AG's assistants, Trevor McFadden, who is going to be overseeing the criminal division in these cases, he's another one who's got all the right resume. He worked with a deputy AG in the Bush administration. He was an assistant USA in, I think, Washington. He worked at Baker McKenzie, like just the sort of background a compliance officer would like to see, and will make you feel comfortable that this person now on the prosecuting side feels our pain. And I think that one of the big questions is going to be more that the administration in the Trump world, all of these minions, these are going to be good people. The wild card is always going to be Trump himself trampling around the White House and Washington and the Twitterverse saying Lord knows what. I don't know how much his trampling and incoherence might affect these kind of cases. I'm hopeful it won't be much, and there are a lot of good people who will be working under Sessions that compliance community can feel comfortable with. But you're always going to have this wild card at the top, and Lord knows what might happen there.
So, gentlemen, unfortunately, we're near the top of the hour, but I wondered if anybody wanted to close with some final thoughts, and maybe, Jay, we could start with you.
Sure, Tom. I think that we've gotten a multitude of different views today, dealing with the implications of this global Rolls-Royce matter and, trying to look at the tea leaves and figuring out where it's going to fall. It's still way too early. So, we can either be glass half empty or glass half full. And, I would like to echo Matt's thought that we're not going to know what this FCPA world is going to look like until we see a tweet from the real POTUS. So I guess I would just confirm that there's indecision out there. But I think the way I read this case is that there's a lot of hope for the global community. And to reiterate what I said before, if there is a loss of funding or clout with the SEC and the DOJ, I feel pretty good that there'll be other people there to pick up the mantle.
Michael? All right. Mr. Kelly.
Oh, no, sorry about that. Sorry about that. I only have one comment to make, which is all those predictors of doom. As my kids are all worried about the new administration, I tell them we've been through worse. At least I hope we've been through worse. And I felt very close to my years growing up with the Nixon administration and watching some of the actions, and I thought very clearly about the firing of Archibald Cox and the night that occurred, and sort of there is a pessimism out there, but I said we've been through worse, and this country has rebounded. That being said, I do think we should look at a constitutional amendment to allow Obama to come back, but who knows? And I'm sorry to be so partisan, but it's a tough time these days.
So, Mr. Kelly from Cambridge.
Yeah, I just want to give a shout out to the Office of Special Counsel, I believe it is, in the federal government. I don't know if people saw this, but essentially that office this week gave a retaliation warning to Donald Trump himself when this is the office in charge of protecting federal employees who are blowing the whistle on their own agency, if they might see misconduct or fraud there. And so amid all of Donald Trump's clamping down on all communications by the EPA and the Interior Department and various others, the Office of Special Counsel sent out an alert reminding all employees that you still have the right to speak out about whistleblower misconduct if you see it. It is a not so subtle, but not entirely pointed reminder that you cannot slap a retaliation warning on employees in the federal government. I'm not sure that Donald Trump knew that. I'm sure he would not like it. I have seen other non-disclosure agreements he has forced on people in his private sector world, and they are vast and extensive. And, of course, retaliation for us at the public company world that is also against SEC whistleblower rules. So I think a small bit of credit to that small agency I was not really aware of all that much for stepping up and reminding everybody that as much as the president may be a blowhard, he can only blow so hard before whistleblower retaliation might step into play. So you still have protections if you're out there. And it was good for them to speak up and remind people of that.
And I would just like to end by noting that yesterday Roy Snell called Matt Kelly the most humorous commentator in compliance. So, gentlemen, with that, thanks very much. And it's been a great podcast. And I look forward to continuing the conversation.
Thank you.
Hello, everyone. This is Tom Fox again. I'm the Compliance Evangelist. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast. It would help in the rankings. Also, if you'd like to pose any questions to our panel, please shoot me an email at tfox@tfoxlaw.com. This is Tom Fox. Thank you very much for listening to this episode of Everything Compliance.